Mr. Mladić, you may proceed.
Thank you, Your Honors. Before I return to my submission, I'd like to address the question by Judge Mladić to get the precise words used by the witness in court. And this is at transcript page 10,880, lines 15 through 23. Quote, Judge Fluge, and you are asked by this person about an event which happened in Karakai. Is that correct? The witness, interpretation, yes, he asked me where it happened. I wanted to avoid that, and I said, in Karakai. Judge Fluge, you said in Karakai. What did you say in Karakai? The witness, interpretation, he asked me where I was shot, and I replied, in Karakai. And it is dated 31st of July. I was already in such a psychological state that some things may not be quite correct. End quote.
Is Karakai, what is Karakai? A place?
Karakai is a place, Your Honor. It's another geographic
that doesn't
location.
Explain whether he was shot or injured. Whether he was shot or it was an explosive. And the question to you was he, your contention is that he was not shot.
Correct.
And I said, go and find out the correct word that he used about his wounds.
And in this section, the witness said he asked me where I was shot.
Sure.
And I replied in Karakai. So that is in relation to this incident. That is what the witness said in his testimony in this case.
Okay. So he contends he was shot. The medical records say it was an explosive.
That's the defense position, yes, Your Honor.
Thank you.
Turning now to Shirokacha. It is the prosecution's case that the city of Sarajevo was heavily shelled, damaging and destroying civilian targets, causing the deaths of several civilians and injuring others from on or about 28 May 1992, which forms Schedule G1 of the indictment. The prosecution cite supporting evidence from 3 witnesses who address the shelling of different parts of Sarajevo, including the neighborhood of Shirokacha. This is Annex B, Roman lowercase numeral 20, with the contention that Serbian forces were responsible. The evidence presented by the prosecution to this extent is not capable of supporting a conviction, as it fails to prove that the Serbian military strategy was responsible for and had the intention to spread terror amongst the civilian population. It is for the prosecution to prove, A, by which side this military action has been authorized against unlawful targets. B, that within those illegitimate actions there was the intent to target the civilian population in order to terrorize. C, that the intent to kill civilians existed. D, that the intent to inflict injuries other than murder existed. Your Honors, that is the requirements as set forth in the Mladić case on the motion for judgment of acquittal under Rule 98 bis on behalf of the defendant, General Stanislav Mladić, 2 September 2002, Section 7. In the prosecution pretrial brief, in Public Annex B, page lowercase Roman numeral 20, the prosecution has down that there are 3 witness testimonies which support General Mladić's guilt in relation to Schedule G1 of the indictment. These witnesses are RM-115, RM-120, and RM-168. Both RM-115 and RM-120 are protected witnesses that gave evidence before the Chamber on 27 August 2012 and 29 through 30 January 2013, respectively. However, the sole eyewitness to support the prosecution's case in relation to Shirokacha is the remaining witness, Fadila Tarchin. While the other 2 witnesses testify about other areas in Sarajevo. This witness gave evidence about the incident in Shirokacha on 28-29 May 1992 via a 92 TER statement and addendum and oral testimony on 2 October 2012. The prosecution has not called any other survivors who could provide an eyewitness account of the events, any military insiders who could attest to the military strategy and intent of the armies, nor any expert or expert reports that support the prosecution's contention that the Serb forces were responsible for the attacks in Shirokacha specifically. Recourse to Tarchin's evidence demonstrates that there is a total collapse of the prosecutor's case and therefore that an acquittal should be entered. The witness's 92 TER evidence does not explicitly attribute the shelling to any particular force. Her written evidence notes a subsequently broadcasted, intercepted conversation, allegedly featuring General Mladić, but states that she, quote, never linked it to what happened to her, end quote, which is page 3, paragraph 12 of her witness statement, which is Exhibit P 00281. In the Rule 92 TER addendum, P 00282, she states at page 2, paragraph 3, that she heard from locals that the shell that wounded her was fired from Borje, due east of Shirokacha, and that she was able to see where the shell had impacted on her neighbor's house. When subject to cross-examination, Tarchin explained that the impact of the shell on her neighbor's house, quote, was facing downhill, that is to say, facing town, end quote. That's transcript page 3,347, lines 20 through 21. When asked by the chamber if this meant that the impact was from the direction of the river, from the valley, rather than from uphill, the witness answered in the affirmative at transcript page 3,347, lines 22 through 25. This evidence stands in direct contradiction to the prosecution's case that the Serbian forces were responsible for the shelling. As she indicated, the directionality of the shelling to have come from within the city, thus indirectly attributing it to the Muslim forces. On this basis, the prosecution's case in relation to Shirokacha has collapsed, as there is simply no evidence that supports their case and is capable of sustaining a conviction against General Mladić for causing and authorizing this shelling that injured witness Tarchin. With regards to intent, if on the basis of Tarchin's evidence, the prosecutor is unable to prove that Serb forces were responsible for the shelling of Shirokacha, then it cannot show that military action to the end was authorized by the Serbs with the intention of targeting the civilian population. Thus, on the basis of Tarchin's evidence, the prosecution's case has collapsed in relation to the shelling of Shirokacha, and a judgment of acquittal should be entered. Your Honors, I will now address the defense's submission challenging the veracity of the prosecution's individual charges as to religious sites under the ambit of Rule 98 bis. Under counts 7 and 8 of the indictment, the prosecution alleges that destruction of cultural monuments and religious sites is a part of their case against General Mladić.
Mr. Mladić, in order to avoid any confusion, you were quoting transcript page 347, unless that's a mistake, the downhill passage, which, according to my system, should be 3447, so as to avoid anyone later not finding it.
Thank you, Your Honor. Your records are much more reliable than mine as I stand here.
Well, we have the same records on our computer, so.
Schedule D of the indictment contains the various municipalities and site locations which are alleged to comprise the prosecutor's allegations as to destruction of religious sites. We respectfully assert that the prosecution's case presented at trial has been deficient and has failed to meet even the reduced burden of proof to survive the Rule 98 bis stage. For this reason, the defense invites the chamber to throw out this segment of the prosecution's case at this stage, because its case has completely broken down to the extent that the prosecution is left without a case. To maintain the charges would be to force the defense to dedicate precious resources to counter charges that are indefensible on the basis of the evidence proffered. Once again, the defense reiterates that the purpose of the Rule 98 bis proceedings is to strike out allegations that the prosecution has failed to adduce any evidence capable of supporting a conviction to ensure due process and expeditiousness, and urges Your Honors to keep this at the forefront of your thoughts during the next submission. Of specific relevance to the objections raised by the defense is the appeals chamber judgment in Hadzi, Hasanovic, and Kubara at paragraph 51. It was held that the accused's right to a fair trial may be infringed if he is erroneously required to answer the prosecution's case. I urge Your Honors to take into account that if the goal of these proceedings has been the ascertainment of the truth, the evidence adduced by the prosecution must be assessed as to the truth it has revealed, and if it is wholly inconsistent with the allegations of guilt in the indictment and the prosecution pretrial brief, the relevant charges against General Mladić must be stricken and dismissed at this stage. As such, we submit it would be an infringement of General Mladić's fair trial rights if forced to expend resources to defend against the allegations relating to destruction of cultural monuments and sacred sites. I note from the outset that there has been no proof that General Mladić ordered or is criminally liable for the crimes of others as to destruction of sacred and religious sites under any mode of liability. There are a total of 11 municipalities that remain a part of this case. I will focus on the three most glaring examples of how the prosecution's case has failed to support these allegations. I will address Bijeljina, Kalinovic, and Pale municipalities. Schedule D1 relates to three locations in Bijeljina municipality, consisting of 3 mosques. The prosecution pretrial brief at Annex B, Schedule D, page lowercase Roman 11, specifies that for these 3 mosques, the prosecution's best case cannot even identify any known perpetrators for their destruction. The pretrial brief identifies 2 witnesses, RM 618 and RM 513, and 2 documents, 65 tur number 03431 and 65 tur number 13410, that are meant to support and prove the allegations as to these 3 sacred sites in Bijeljina. Your Honors, neither of these 2 documents have been admitted into evidence, and thus cannot be relied upon to support this allegation at this stage. RM 618. That is the expert report of Andres Riedelmeier. During his in-court examination, Mr. Riedelmeier did not offer any testimony as to these 3 mosques in Bijeljina. P2513 is the expert report produced by Mr. Riedelmeier. There is an annex to the report which purports to give information about perpetrators of the destruction of sacred sites. There are 4 entries for Bijeljina. None of them are identified as the 3 sites that are set forth in the indictment. Incidentally, for the 4 sites that are referenced, the sole source relied upon by Mr. Riedelmeier is informants' statements and news reports, although only one informant is identified for each. P2503, another expert report of Professor Riedelmeier, likewise has no mention of these 3 locations in Bijeljina. P2511 is the database offered by Mr. Riedelmeier into evidence. At record number 13 of the same, the Atamačići Mosque in Bijeljina, there is no information on the alleged perpetrators of the destruction, nor any particulars as to the date or the manner of the damage being inflicted. The sole source is anonymous hearsay information in the Mejlis of the Islamic community.
Is the Atamačići Mosque one of the 3?
Yes, it is, Your Honor. To be clear, the 3 that are listed in the indictment are Atamačići, Janjari, and Srednja Trnova. As to the Janjari Mosque, this is record 14 of P2511, and again, it gives no information as to alleged perpetrators, the manner, and date of the damage. Indeed, there are 2 equally anonymous hearsay sources relied on by Riedelmeier, one which states that the mosque was destroyed, whereas the other states that the mosque was in an unfinished state of construction when the war began and was never finished. As to the 3rd location in the indictment for Bijeljina, Srednja Trnova Mosque, this is record number 15 of P2511. And again, there is not sufficient information as to perpetrators or the manner of destruction. In fact, the information is that residents say it was intact when they left and found destroyed when they returned. Again, the source of the information is unknown hearsay declarants as reported by another hearsay source. In each of these cases, the evidence at best provides not a single eyewitness account that could identify the perpetrators or manner of destruction to prove the allegations in the indictment. The other records pertaining to Bijeljina in Riedelmeier's report cannot be relied upon or reviewed by the Chamber, as they are not specified in either the indictment or the pretrial brief. RM 513 is a protected witness who testified about a wholly different subject, and in their in-court testimony made no reference of these sacred sites or of what happened to them. P1054 under seal is the statement of this individual. Following the guidance of your chamber, and I think it's important for the public to hear, I will talk about what is in the statement without revealing the identity of this witness, so that the public can see what type of evidence is being presented by the prosecution on this score. Paragraph 77 of this statement makes no specific mention of these particular religious sites set forth in the indictment, but rather states that unnamed sites were destroyed, and as to the source says, quote, "This information was spoken about in Bijeljina," end quote. Rumor and unknown hearsay, Your Honors. that is the best case this prosecution has been able to offer as to these 3 sites from Schedule D1, bolstered by unsubstantiated accounts of other sites that are not even in the indictment. Is it fair to force an accused to answer such allegations? In the Mladić Rule 98 bis decision, at transcript page 11,311 through 11,312, the court, relying on the Mladić Appeals Chamber, stated in essence that the chamber is required at this stage to assume that the prosecution's evidence is, and I quote, entitled to credence unless incapable of belief. Quote, in essence, a Rule 98 bis motion will succeed if there is no evidence supporting a particular count, or if the only relevant evidence is so incapable of belief that it could not properly sustain a conviction, even when the evidence is taken at its highest for the prosecution. Your Honors, I submit the foregoing can be regarded as either not being any evidence or evidence that is incapable of belief. Just the other week, the ICC had a judgment issued by the appeals chamber in the Bosco-Nittiganda case. And I would like to discuss with you the dissenting opinion of Judge Christine Vanden Wijngaard, who Your Honors know as she was a former colleague of the bench at the ICTY. Judge Vanden Wijngaard stated, quote, I am also of the opinion that the pretrial chamber 2, hereinafter pretrial chamber, erred in its sole reliance on anonymous hearsay evidence contained in press releases, blog articles, and 2 UN group of expert reports. Such evidence must be treated with utmost caution in the context of a criminal trial and without considerably more independently verified information cannot, in my view, be safely relied upon to justify the continued detention of Mr. Bosco Nittiganda. Judge Vanden Wijngaard continues, the International Criminal Court, hereinafter ICC, and ad hoc tribunals have traditionally employed a flexible approach to the admissibility of evidence, ostensibly a civil law influence within a broadly adversarial system, rather than systematically rejecting the admissibility of any particular category of evidence. Judges have been afforded broad discretion to balance probative value with prejudicial effect. However, the fact that certain types of evidence, such as anonymous hearsay, are not automatically excluded from the proceedings does not mean they are therefore safe to rely on. Whether they are or not can only be determined on a case-by-case basis, which, in the case of anonymous hearsay, is a difficult task considering the sources of the information are unknown. At the ICC, too, pretrial and trial judges are more and more relegating anonymous hearsay evidence to something which can, at best, potentially corroborate other evidence rather than as standalone source of information that possesses significant probative value per se. Judge van den Wijngaard concludes, what I think warrants emphasis, however, is that this more cautious approach to anonymous hearsay evidence is not something that derives from the whim of a number of judges. Instead, it brings us closer to the standard that always should have been applied when assessing such evidence. Indeed, I'm not aware of any other system of criminal justice, be it national or international, where anonymous hearsay is given any serious probative value if it is considered / admitted at all. I can think of no good reason why this court should take a different approach, let alone what could justify basing judicial decisions pertaining to the freedom of individuals on evidence that is inherently fragile and against which the subject has no meaningful opportunity to defend him or herself. End quote. Your Honors, we respectfully submit that the logic behind Judge van den Wijngaard's words applies equally here to the ICTY, and especially at this stage, and to allegations in the indictment that are not supported by any other evidence save for anonymous or unknown hearsay. I would now direct your honors to Kalinovic. The indictment identifies at Schedule D6 4 mosques in Kalinovic for which the criminal responsibility of General Mladić is asserted. The prosecution pretrial brief, again, is unable to identify any alleged perpetrators, let alone any persons that General Mladić would be responsible for. As to Kalinovic, no documents were identified as supporting this allegation, and there are 3 witnesses: Mr. Riedelmeyer, RM035, and RM034. Again, Professor Riedelmeyer in court offered no evidence as to these 4 locations in Kalinovic. P2513, his expert report as to Kalinovic, only has an entry for the Ulog Mosque and not the other 3. As to the Ulog Mosque, it is not specific as to who blew up the mosque, when, or for what purpose, except to say it was done by Serbs and is based, according to the information from the Center for Islamic Studies, again, unknown, anonymous hearsay. Looking to P2511, entry 168 is the Ulog Mosque, and this offers no support for who destroyed it. Entry 169 is the Hotovlije Mosque in Kalinovic, and again, there is no information contained as to the perpetrators or the manner of destruction that suggests criminal liability. The only sources listed for the scant information are the Muslim Community Center archives and an unknown anonymous informant interviewed by the OTP who wanted to remain anonymous for security purposes. What is significant, Your Honors, is that this same expert report of Mr. Riedelmeier concludes for entry 169, based on multiple independent sources, that there never was any mosque in Kutina village. This is significant because the fourth mosque cited in the indictment for Klinovic is precisely this non-existent mosque in Kutina. Lest I be accused of getting ahead of myself, the third site in the indictment for Klinovic is Jesalica Mosque, which is not even to be found in the database of Mr. Riedelmeier. So after many years investigating, the best case the prosecution can put forth as to Klinovic is expert evidence which confirms there is no mosque in Kutina at all. Damage can be confirmed only to 2 out of the 4 mosques as a result of unknown perpetrators, unknown cause, etc. Let's now turn to the witnesses. RM-034 testified in court on a wholly different topic, but was asked in passing about mosques, again, very unspecifically. Ms. Bibles, at transcript page 1838 through 1839, asks as follows, quote, question, could you tell us whether you're aware of who destroyed the 4 mosques in Klinovic? Answer, all 4 mosques in Klinovic were used before the war, except for one of them, the one in Velisi, phonetic. From 1991 to 1995, all 3 mosques on the territory of the municipality of Klinovic were torched, the minaret was blown up, and the one in the village, the interpreter did not catch the village, the name of the village, the witness. And the one in the neighboring village was also destroyed. Judge Ori, 1 minute, Mr. Hadjic. The question, and I would like you to focus your answers on what is asked, is who destroyed the 4 mosques? Not about how they were destroyed, but who did it, whether you have any knowledge about it. Can you answer that question? The witness, I do have an answer. It was done by the Serb army, end quote. First of all, there's absolutely no identification of any of the mosques that would tie them to those 4 listed in the indictment. From expert Riedelmeier, we know one of the 4 never existed. Only 2 of the 4 were damaged. The testimony of RM-034 is thus incapable of belief on this matter. We have nothing that one would expect to establish the prerequisites for a crime. Again, rumor and anonymous hearsay, evidence incapable of belief. RM-035 did not testify in these proceedings, but rather a written statement was presented under Rule 92 bis. His statement contains no mention of mosques, as that has been redacted pursuant to Adjudicated Fact 746. This adjudicated fact, taken from the Krajišnik trial judgment, merely states that, quote, the mosques of Klinovic, namely in Ulog, Hotovolje, Kutina, and Jelasica, were destroyed during the war, end quote. This adjudicated fact is rebutted by the expert report of Riedelmeier because Kutina Mosque didn't ever exist. Surely we have not come to a point where the defense must mount a defense against a prosecution case that is based solely on an adjudicated fact, which says nothing specific about the manner of damage or destruction or the perpetrators, and which has been refuted as partly untrue by the only expert to testify thus far. Is that within the spirit and meaning of Rule 98 bis to remove such charges at this time? I would argue that the Chamber should remove the same in accord with the purpose and function of the provision. Let's look at Pale, which in the indictment is Schedule D10, and for which 3 mosques are to be charged. Pracha, Podvitez, and Bogovici. The prosecution's pretrial brief, again at page Roman numeral 11 of Annex B, Schedule D, is unable to provide any identification of alleged perpetrators. One document, 65 tier number 13410, and 3 witnesses are identified for the supporting evidence on this charge. Your Honors will not be surprised, since I'm bringing it up, the document in question also was not introduced into evidence in this case. One of the witnesses listed is Professor Riedelmeier. Professor Riedelmeier did not offer substantive testimony in court on these 3 locations in Pale. P2513, his expert report, likewise does not make reference to any of these 3 locations. Turning to P2511, the database of Professor Riedelmeier, entry 172 is the Pracha Mosque. Again, the only source is according to the records of the Islamic Community Center, and there is not any information about who caused the damage or for what end or purpose. Podvitez Mosque is record 173 in P2511. And again, the only source is according to the records of the Islamic Community Center, and there is not any information about who caused the damage or for what end or purpose. Bogovici Mosque is record number 174 in P2511. Again, the only source is the records of the Islamic Community Center, and there is not any information about who caused the damage or for what end or purpose. All this is unknown, anonymous, hearsay information that does not itself meet the bare minimum to assess criminal liability. Let's look at the witnesses. RM111, who testified at trial, was asked in direct examination at transcript page 3148 through 3149 as follows. Quote, question. And you say in your statement, sir, that you heard after you left the mosques in Pale were destroyed. You referred to the period between July and September 1992. Who controlled Pale at that time? Answer. At that time, Pale was under the control of the Serbian Democratic Party. Once again, anonymous hearsay information. This is confirmed in cross-examination at transcript page 3155, that the witness learned all this after the war from unknown others. Again, there is no specification of the perpetrators, apart from labeling them as Serb forces. The witness's 92 ter statement, P260, at paragraph 79, claims that these mosques were destroyed after the witness left Pale, and that the information is, quote, common knowledge, end quote, in Pale. Again, rumor and unknown anonymous hearsay. The other witness listed in the prosecution pretrial brief for Pale is RM 619. Your Honors, RM 619 was Eva Tabo, the demography expert who offered no evidence as to mosques. So we are left with the evidence that I've already discussed. Can barely be called evidence, and surely is not evidence that is capable of belief. Surely it is not the type of case that this chamber would force the defense to expend resources to defend against. Your Honors, as our time is limited, I have gone through 3 of the 11 municipalities in Schedule D and demonstrated the prosecution case to be deficient as to each. I would ask that you scrutinize the evidence as to each remaining charge and dismiss same if found to be similarly lacking. The defense has not taken a scattergun approach to the charges that it seeks acquittals on simply for the sake of it. Rather, challenges those that it can show that no evidence capable of supporting a conviction has been proffered by the prosecution. It is for these types of isolated incidences that the charge-based approach is appropriate and the legal veil should be pierced as an exception to the rule, as this approach adheres to the object and purpose of the rule. With this in mind, as the defense has shown, that the prosecutor has failed to adduce evidence capable of supporting a conviction in relation to the incidents at Yada River and Shirokacha and Schedule D, it urges the chamber to enter a judgment of acquittal on these charges to make a clear statement that the allegations that are incapable of sustaining a conviction at this stage will be purged from the indictment, to assure that defense resources are not squandered, that due process is upheld, and that the prosecution cannot hide behind a legal veil to surreptitiously push through those allegations for which it has no evidence capable of sustaining a conviction. Following the jurisprudence and adhering to the count-based approach renders the provision worthless, and the right of the accused to an acquittal at this stage on charges that the prosecution has failed to substantiate unobtainable. Today, Your Honors have the opportunity to make a clear statement that the provision is more than just one that adheres to the rhetoric of a fair trial. To truly bring war criminals to justice, the trial process must be conducted in a manner that preserves and protects the accused's rights. You have the opportunity to demonstrate that the fight against impunity will not be exploited as a slogan to justify interpreting provisions in a manner that curtails the rights of the accused, and a crusade for the prosecution to hide behind when there is simply no evidence. The indictment at paragraph 34 asserts both Article 7.1 JCE and 7.3 Command Superior Liability against General Mladić for failing to take necessary and reasonable measures to prevent and punish crimes alleged to have been committed by VRS forces and so-called Serb forces under his effective control. The indictment at paragraph 12 identifies Serb forces as comprised by members of the Bosnian Serb political and governmental organs and members of the MUP, VRS, JNA, VJ, TO, the Serbian MUP, Serbian and Bosnian Serb paramilitary forces and volunteer units, and local Bosnian Serbs. In essence, this indictment is not leveled merely at General Mladić, but at every single Serb, an objection that the defense raised at the preliminary stage as to the lack of specificity and notice compliance under the jurisprudence resulting from the prosecution's construction. We would remind of the jurisprudence of the ICTR, the Bagambikou case in 2004, which set a high standard of specificity for JCE in indictments. That chamber made clear that the prosecutor must specify in the indictment which form of JCE she argues, the purpose of the enterprise, the identity of the co-perpetrators, and how the accused participated in the enterprise. This was in paragraph 34 of the judgment. Nevertheless, we are still left with this broad definition. We should now look to the evidence that has been presented to try to whittle down this broad allegation to fit the evidence that has been presented for which a case may go forward.
Mr. Mladić, could I just interrupt you for 1 second? You refer to paragraph 34 of the indictment asserting
the Bagambikou judgment in 2004, Your Honor. That's ICTR 99-46-T, 25 February 2004.
No, the paragraph before that. The indictment at paragraph 34 asserts
Ah.
both Article 7.1 JCE and 7.3 command superior liability against General Mladić.
Yes.
That's the one. I'm wondering, how should we, in your view, read paragraph 34? Should we read that he failed to take the necessary and reasonable measures to prevent the commission of crimes, which would mean the commission by others, the others committing the crime either under 7.1 or 7.3? Or do you read it that paragraph 34 also includes to charge General Mladić with having committed the crimes under 7.1 himself, any of the modes of liability of 7.1? And I'm also looking at Mr. Groom, perhaps to see whether he has any explanation in this respect.
I think the answer is found in the heading of that section. It's clearly limited to 7.3 of the statute. 7.1 liability is discussed throughout the entirety of the indictment.
Yes, so in paragraph 34, the reference to 7.1 is primarily to 7.1 liability of those under the command of General Mladić. Or is it just in addition to repeat in every respect that if it's not 7.3, then it's 7.1?
That's the more correct interpretation. And just so that the record is clear, the 7.1 liability also applies to all of the parties. I think it was paragraph 12 that Mr. Mladić referred to, where we defined members of this joint criminal enterprise and the people they implemented their criminal objectives through.
Okay, that clarifies the matter.
And that's how I understood it, Your Honor.
Yes, please proceed.
The Office of the Prosecutor, actually, Your Honors, I think it's time for the break. Is that?
Yes, it is time for a break. We'll take that break. Mr. Mladić, could you update us on where you are in terms of time? I do understand that out of the 4 items you would like to bring to our attention, that have we finished the third, and are we now
We're starting on the third right now.
on
So
the third?
Yes.
Okay, and do you think that you would finish today, which is the
Yes.
as scheduled? That's appreciated. We take the break and we resume at 10 minutes past 12 o'clock.
All rise. Oui, vous levez.